This is Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Wow. Welcome, Gary. I like it. You've got, looks like you're at the Los Angeles Taco Central there, right?
Absolutely. And no bucket this time. I'm in a much better place than the last time we spoke.
It would hardly be a vote of commendation for the last establishment that you ate at if you had to carry the bucket around behind you, right?
Yeah, absolutely not. That would not be a good endorsement whatsoever. Yeah, I'm sure it wasn't one of the taco places that's over my shoulder. Those are all fine establishments.
Yeah, exactly right. I love to hear that. And I'm going to probably go to Dirty Taco tomorrow, so I'll give a shameless plug there over at Grand Central. I'm very, very interested in the E. Jean Carroll trial with President Trump. He was, I think, the plaintiff, E. Jean Carroll, the lawyers rested on yesterday, Thursday.
Correct.
And the judge gave Joe Tacopina, who is the defense lawyer in the case, I believe until Sunday at 5 to make a decision. Apparently, the president was making a comment to a reporter in which he said he was returning from overseas to confront a woman. You got that? Look at you.
And I have to go back for a woman that made a false accusation about me, and I have a judge who's extremely hostile. And I'm going to go back and I'm going to confront this one. This woman is a disgrace, and it shouldn't be allowed to happen in our country.
Are you going to Yeah. So the Tacopina said, I think, Your Honor, you know what I'm dealing with. I assume that's the logistics. I don't think he was slamming his client.
No, I doubt it.
Yeah, and so the judge, even though he's saying this judge is extremely hostile to him, and you can make that argument, I suppose you could say that the judge has been at least...
He's certainly been giving it to Joe.
I was going to say unforgiving. And so the ex-president has until 5 o'clock Sunday to notify the court that he wants to testify. And it looked from that like he does. I've been saying, as you know, Gary, that it's a civil case, which is basically just a little more than 50-50 in terms of the evidence. And if it's a civil case and you're not there and the jurors are, and they're taken away from their work to be in court every day, it's very hard to, with a straight face, ask them to fine for your client who couldn't make the time to show up.
Right. Absolutely. So does that surprise you? I mean, do you get the sense that this is a last ditch effort, or is this just Trump blustering in the press to, make headlines?
It would surprise me if he took the stand. However, I think one of the worst things, he's denied that it ever happened. She can't place the date. So there really is very little for him to lose other than, look, which way do you want to get stamped if he loses? That you didn't testify and be branded a civil or a rapist to the degree of the standard of evidence, or that the jury didn't buy anything you were selling. I think the jury didn't buy anything you were selling is a better solution. If I was counseling him, I'd say, well, you got nothing to lose. They get in there and see if somebody can, if you can convert one or two of the jurors your way. And mind you, it's not like they didn't get in some body blows. They, meaning E. Jean Carroll. I think you've got one of them, don't you?
Yes, I do. This is from the deposition that her team did with President Trump, former President Trump. Let's see here, right here.
And do you recall when you first saw this photo?
At some point during the process, I saw it. That's, I guess, her husband, John Johnson, who was an anchor for ABC. Nice guy, I thought. I don't know him, but I thought he was pretty good at what he did. I don't even know who the woman. Let's see. I don't know who. It's Marla.
You say Marla's in this photo?
That's Marla. Yeah, that's my wife.
Which woman are you pointing to? No, that's
Here.
Carroll.
Oh, is that,
The person you just pointed to was
I
Eugene
see.
Carroll.
Who is that? Who is this?
Point, your wife. And the woman on the right is your then wife.
I don't know.
Ivana?
This was the picture.
Ivana.
I assume that's John Johnson. Is that
That's Carroll.
Carroll? Because it's very blurry.
Doesn't look that blurry to me. I don't know. I sort of laid that. The clip that is pulled from does not have that photo overlaid on it. I did that for the ease of our listeners.
Gary did, by the way, Gary, if you ever need another career audio visual and litigation support would be a good thing, because what Gary did right there was to take the picture that the president was looking at and then superimpose it so you could see it. And that's a very effective way to do it, especially when you don't have a witness in the courtroom and you want to give the jury the flavor of what it is, because clearly he's looking at a photo that most people would say is a much younger Eugene Carroll, and it appears to his right is his other wife, and not Marla. So I don't know if he got confused or what. You noticed also there was some closed captioning of his lawyer trying to rehabilitate him in real time, or at least direct him to some degree. That was, I would not call that mortifying. I would say embarrassing, and I would say it tends to undercut this idea that she's not my type. But I'm sure that he can get up on the stand and dance around that. I think that's his only. I don't see how he wins this otherwise.
Yeah, it doesn't seem likely. I mean, especially the thing I thought that was somewhat funny or interesting about that clip is that at a certain point he puts it down on the table so you can see on the video and points right to clearly Eugene Carroll and trying to assert that is his wife. I don't know. It's again I agree.
Adam, you had done for Adam at one point kind of a synopsis of what his type was, and had put up, as I remember, you had his first wife, you had Eugene Carroll, you had Marla Maples, and you had Melania. I thought as a kind of in my line of work, we do 6-packs, but I think you had it as a 4-pack, which is some other jurisdictions do 4-packs as opposed to 6-packs. And that I thought that was, there you go. Very good. What's his type? So he had confused on the left, and that looks very similar to how she looked in that picture that they used in the deposition. And in the middle is also Mrs. Trump, the first. She calls the first lady, or as she did before she passed, untimely passed, and then Marla Maples, and then Melania. So I suppose you can make an argument there that Eugene Carroll is his type.
Yeah, I certainly, this photo, it makes it hard to argue against. I mean, these, not identical looking women, but they all certainly seem to share several distinct features, I would say.
Yeah, I could distinguish, or I could make the argument for similarities. I'll ultimately remember the idea here is that that he had made the statement, she's not my type, she'd made it up, blah, blah, blah. So he wants to deal with that as well. And he's got his hands full, and we'll see. We'll know on, I do not believe before we do Sunday Bard that we will know, unless he wants it to kind of trump the news cycle on Sunday. So, but we'll follow up there. Now, another one I always like to share with the listeners and subscribers, the Menendez case, which we talked about.
Right.
And in full disclosure, I have signed on to that case, and we have filed we meaning Cliff Gardner, appellate lawyer extraordinaire, and I have filed what's called a writ of habeas corpus, which is basically saying that he's being held, that the brothers are being held, Eric and Lyle, and without cause at this point. The reason for that, and let me set the stage, and for those who don't remember, they were convicted after 2 trials, first trial hung, of murdering their parents, Jose and Kitty. And the allegation in the first trial, the defense, if you will, was that Jose had abused Eric, and that was continuing to abuse him, the jury hung with half of the jury voting that Eric was not guilty. Lyle was also a hung jury, and they were very ably defended by Leslie Abramson. They got in the abuse, and that was to negate the malice required for murder. So the jury was not going to acquit them, but the jury was saying, we're not going to find you guilty of murder, or at least half the jury was. So then after that first trial, a mistrial is declared. And then before the second trial, there was an intervening cause, if you will, which was the O.J. Simpson acquittal.
Right.
And then the second trial comes along, and on the heels of the acquittal, and all of a sudden, the judge and the DA basically get their way, which is the rulings which were allowed in and the ability to testify why you did it, they got it excluded. And the DA in the closing argument made the bold assertion that they had fabricated the abuse, and that they were just basically wealthy, rich white kids from the West Side who wanted to live like they could without any repercussions.
And for people who maybe aren't in the weeds, can I point out, I think it was the exact same judge in both trials, right? So that judge got a chance to sort of take a breather, kind of survey the landscape, and then take another shot at this and rule maybe in different ways depending on, what the instance was.
Right. And he excluded their defense, basically. And now what has happened recently, and one of the reasons, I've talked with Adam for years about this case. Adam's one of the guys who said, just substitute gym coach for Jose and Menendez, and would anybody say that's murder if the gym coach was molesting? And has made a pretty cogent argument that if Natalia and Sonny had come into the room and shot Adam and his wife, blew him away. And he always, I'll tease Natalia, he's always said it would be at Natalia's behest.
Yeah.
That he would figure that they probably deserved it, especially if they were eating ice cream on a Sunday night. So what has happened since then is that they've discovered, first of all, a letter that Eric wrote to his cousin, Mr. Cano, who has since passed away. Apparently, this letter was written, at least within a year before the killings. And after Mr. Cano's tragic passing, his effects were stored. And then recently, somebody going through the effects found the letter. And it, by all accounts, and we've attached it to the petition, it would appear that Eric was probably, I'd love to hear Drew's description, but it's horrifying, to say the least. I mean, his dad was obviously, to him, a violent sexual predator. And now also there is a Peacock documentary which just dropped where one of the members of the Menudo band, though some of you may remember that, have alleged that Jose, who was the head of RCA Records, which apparently had the band signed to them, and he used to go to their concerts and everything else, that apparently he was that he had raped that boy as well. And there's now a declaration as to that.
Drugged and raped him, right?
Well,
didn't he alleged to have drugged him as well? Yeah. It's disturbing. So
now we've got those two facts which have coalesced. And so the writ says that Judge, the second trial was unfair. And a lot of people have asked, and I don't know that anybody's done this deep. I certainly did, and asked Gary to take a look and show it. A lot of people have asked, well, what was the change? So instead of just listening to me tell you, we went back into the archives and we found, what was this, Gary, from the Ninth Circuit Court of Appeals sometime in the year 2005?
Yeah, it appears it was in February 2005, and it's a three-judge panel with judges Kaczynski, Trott, and Clifton. And we have a couple of clips here of them with the Deputy Attorney General Kenneth Byrne representing the state. And we'll
yeah, and for those who don't know, even though the DA's office tries the case, the Attorney General defends the conviction. And so that you understand the rulings that were reversed and some of the inside baseball is Dave Kahn, who tried the second trial, he did not try the first, was at the time the scuttlebutt was he was going to run against Gil Garcetti, who had just lost the OJ case. And so the way that they kind of took him off the chessboard was to assign him to this case, and that he was able to convince the judge, same judge, to not allow the abuse defense and get the conviction, and at the same time argue that that it was frivolous and blah, 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 don't buy it, even though the evidence was excluded. Here is the Court of Appeal about 10 years later and about 18 years in the past.
Yeah.
So you have one set of rules, and then you have one trial, and you don't succeed in the conviction, so you sort of change the rules, and they even change the facts.
That happens all the time, Your Honor. In fact, Judge Weisberg at the start of the second trial said, look, there were a lot of rulings in the first trial.
Too, right?
I'm sorry?
You changed the judge, the same judge?
Judge Weisberg was the same judge in both trials.
Okay.
He presided over the first trial. At the start of the second trial, he said, look, a lot of the rulings from the first...
It's a little distasteful that when the state doesn't succeed in convicting somebody under one set of rules, it sort of changes the rules dramatically.
I'm not quite sure.
One jury... Excuse me?
I'm not quite sure what the court means when you say change the rules. There were additional proceedings.
I was about to tell you. You had two juries. You have one. You gave a defense instruction that is now denied for imperfect self-defense. Thus finding that this thing is for, that he was a psychiatrist for purposes of defense. And now the rule is that they're visiting it for purposes of treatment. It looks to me a lot like, gee, we really didn't succeed in nailing these guys, so we can't do it fair and square. We'll try to sort of jimmy things and see if we can't get a conviction some other way.
So that's Judge Kaczynski. I recognize the voice when I look at it. Judge Kaczynski basically saying you jimmied the rules. When he said there were the first trial, you had two separate juries. They did two separate juries, one for Eric, one for Lyle. Second, you combined the juries. When there's we get into the weeds on that. Then he's saying you're not going to allow in the testimony. Judge Weisberg changed the jury instruction. He basically would not allow the jury instruction that would have called for what's called imperfect self-defense, which would have mitigated the malice needed for murder and dropped it to a manslaughter, which, by the way, they've been in for 33 years, and manslaughter would have they've well exceeded the maximum on the manslaughter.
And the reason that they need the imperfect self-defense as opposed to just self-defense has to do with their state of mind, right? And their fear of what might have happened and what was to come in the future. Because self-defense is going to be pretty hard to prove if the facts and evidence are that, mom and dad are sitting there eating ice cream. You could leave the house, you could try to get away. But the imperfect is the reason that, their mind state is coming into play, correct?
Yeah, then remember, it's exactly right. And remember when we were in the 90s, and in the 90s we were not as sophisticated to understand the mental state of somebody who was being raped, and consistently, and especially when you have an incestual rape like this, which is just horrifying.
Well, we do have one more clip featuring the deputy attorney general and the judges. If you'd like to hear that,
I would love to.
Why did the judge give it in the first trial?
I think he made a mistake, and I think he recognized that.
You recognized it when the two juries came back with splitting 6-6?
No, Your Honor, I respectfully disagree with the suggestion that the state trial court tried to, secure a conviction in this case. I think that the only inference that can be drawn in this case is that the judge tried to do the best he could to apply the law to the facts of the case. Sometimes judges change their minds as cases unfold, and I think that
they never read the newspapers.
Your Honor, if the court is suggesting that Judge Weisberg tried to jimmy the second trial, tried to jury rig the case to obtain a conviction because he read articles about this in the paper, I just have to disagree with that suggestion.
We'll never know, will we?
Now, I've certainly never argued before a judge, but it seemed weird to me that Attorney General used the judge's own word from about 15 minutes earlier in their back and forth and brought up jimmying. I don't know. That just seems ineffective to me.
You have to remember the one thing that happened between 1 and 2 was a whole lot of ridicule and a whole lot of mocking, and that's why as the Ninth Circuit eloquently said, you can't just change the rules and jimmy the verdict.
Right. Yeah. It's so what comes next for you? You know, I saw you submitted the writ of habeas corpus. So how does that process play out?
We're waiting, and the DA's office, I think today, said they're evaluating it. I anticipate talking to somebody over there next week and kind of taking the temperature and showing them anything else that we've developed, and probably having a discussion. They've served 33 years, which, as I said, greatly exceeds what the maximum punishment ever would have been for voluntary manslaughter, which is based on what we know now, all they ever would have been convicted of. And it seems like it's time. The time has come. The culture has changed. Our understanding is more sophisticated now, and it's a different time.
And if you were to end up successful, I mean, getting them out, I mean, that would be a victory, so to speak. But then would there be a possibility of going after the state for, them being incarcerated for too long?
No, I mean, as of that, I don't want to foreclose anything, but the judges have immunity, prosecutors have immunity. You've heard me rail about qualified immunity for years. That's hardly anything that's ever. At this point, my main goal is to get them out.
Well, it'll be very interesting. I'm excited that we'll be able to follow it closely, because I'm sure it'll be top of mind for you as this unfolds.
It absolutely will. And thank you, Gary. Will I see you on Sunday? You're in the pink now?
Yeah, absolutely. I'll be there for sure.
I love it. Well, thank you so much. Thank you, everybody, for listening. Mother's Day is coming up. Go to alexandani.com for some affordable and really meaningful gifts. They've got a Mother's Day curated collection that's great. It's ALEXANDANI.com. Love is a superpower. Moms are love. There you go. Shop meaningful jewelry at alexandani.com. Thanks so much.
Thanks, Mark. We'll see you Sunday.
See you Sunday. Bye-bye.
Thanks for listening to Reasonable Doubt. Subscribe on YouTube at youtube.com/Reasonable Doubt Podcast.